Okay, I think we're live. Hello, everybody. Sorry that I am the one who's in charge of technology again today. Welcome to another Facebook Live, this time with somebody with the last name Joseph or Hall, unfortunately.
So we're going to stay in control today.
But the rules are going to be enforced. I can't just ramble forever. It is the way it is, I guess. Yeah, so we're going to go through a couple of updates. Once again, I still don't know how to do banners, so that's not going to happen. But we'll, talk about a couple of things that happened this week in the immigration world, and then take some questions. So I guess we'll get started. I don't know, Luke, if you want to start off?
Sure, I'll get started. So I just wanted to give a quick update on Daca. So the latest installment in the legal saga of Daca. So many of you probably heard on July 16th, there was a federal district court judge down in Texas, Judge Hainan. He issued a ruling finding that Daca is unlawful. It violated the Administrative Procedure Act. Basically, they didn't go through the right process to institute the program. So what does this ruling mean? There's a couple implications here, some big implications. One, I think we can kind of divide it into two sections. People who already have DACA or have a renewal for DACA pending or coming up, and then folks who have never had DACA before. So first of all, for anyone who currently has DACA or has a DACA renewal pending, this decision right now doesn't do anything to change that. So if you have DACA right now, you're still, that DACA protections are still valid. You still have DACA. If you have a DACA renewal application pending, it's still going to be processed, and assuming you're eligible, there's no issues with your application. It should be approved. You should get it renewed. And if you need to send a renewal, in the upcoming weeks, you can still do that, and USCIS should process that renewal application. So that's kind of the first thing. So for those who have DACA, basically it's kind of the status quo. The big change comes here for people who have never had DACA, those who already filed an application for a first-time DACA, or those who are considering filing an application for DACA. So the ruling that the judge issued, it basically prohibits USCIS from approving any initial DACA applications. And so if you have an initial DACA application that was pending when this ruling came out on July 16th, understanding right now is there's basically kind of a freeze on those applications. USCIS has not released any substantive guidance on what they're going to do with those applications that were pending. And I anticipate we'll see some guidance from USCIS in the coming weeks. But right now, nothing is going to happen. You're not going to get an approval on that pending DACA application. And you're not going to get a denial at this point either because of this ruling. The other kind of strange thing is if you're eligible to file for DACA and you never have, this ruling, basically it allows you to still file an application for an initial DACA request, but this ruling prohibits USCIS from approving that request at this point. So kind of, it's kind of a strange scenario right there. I anticipate in the next coming, couple of weeks, we'll get some more guidance from USCIS on what folks in that situation should do. Yeah, I think that's about it right now. Do you guys want to add anything?
No, there's a bill in Congress that would take care of the DACA population by giving a path to permanent residency. It's supposedly they're working to pass it through reconciliation, meaning it only needs 50 votes in the Senate. We'll see if it stays in there, and hopefully that would be the thing that resolves this for everybody.
Yeah.
All right. Well, I'm going to take you guys into the weeds of immigration law and talk about things that you probably don't even want to hear about once again. So my announcement is that USCIS has changed its policy on what's called B2 bridges for people who are changing their status to F1 students in the United States. This is a huge change. It's going to make a big difference in a lot of people's lives. And it's going to make a lot of things a lot easier. But I guess to understand its implications, we have to talk about a whole bunch of, I guess, complicated immigration law topics. The first part of that is that there's this distinction in immigration law between lawful status and lawful presence. You can be in the United States with lawful presence, like you're permitted to be here, and that's, for example, people who have been granted DACA, but they don't necessarily have an underlying status that they've been granted, like a K-1 fiance, for example. So there's no underlying status, but they're permitted to be here. Another really common way that you get lawful presence without having an underlying lawful status is by filing an application to change or extend your status and having that previous status that you had expire in the meantime. So let's say you're here on an H-1B, you're filing for your permanent residency, you file your I-485 to get your green card, and while that petition is pending, your H-1B expires. You're okay to be here because you, under USCIS policy, have lawful presence as long as that I-485 is pending, as it was timely filed and everything is good to go on it. But there's no underlying status for you to kind of, I guess, fall back on. No H-1B that you can say that you have or anything like that. So there's this distinction, and it's always been, well, not always, it's USCIS policy for a long time that as long as you have timely filed a petition, there's no other status violations, you haven't been working without authorization, things like that, you're totally fine being in the United States and waiting for USCIS to adjudicate your petition, which makes sense because sometimes they take a really, really long time to adjudicate petitions, as we have definitely been seeing during COVID. The exception has been for F1 students as of 2017. What they said is that you had to maintain lawful status up till 30 days before your program start date. So common fact pattern here is, maybe you came here with your parents and your parents opened a business and you've been a derivative on their immigration status for your whole life. Maybe they are an E2 treaty trader investor. They have their own business and they renew it every 2 years and you go along with it and everything's fine. But you're about to turn 21, so you need to get your own immigration status, and you're going to college, so you're switching your status to that of a student. Right now, I just have the processing time is pulled up. California Service Center is taking 13.5 months to 17.5 months to process a change of status to an F1 student. That means that rather than for any other type of petition where you would just file that initial application and be totally fine waiting for your change of status application to be adjudicated, you have to keep filing what are called B2 bridge applications to keep some sort of underlying status up until the point that your F1 application is finally adjudicated. So that means you just keep filing these kind of nonsense applications saying, this is just for purposes of maintaining underlying status. I have a pending change of status to an F1 student. Please approve this for 6 months. And then you do it again 6 months later. And then maybe you do it again 6 months later. So just a whole bunch of time wasted on your part, on the part of USCIS adjudicators, and money wasted as well, because you have to pay filing fees and I guess go through the time and effort of gathering all the documentation needed to pull these applications together. But thankfully, we just got an announcement yesterday, Tuesday, earlier this week that said USCIS is no longer going to require B2 bridge applications. So now F1 student change of status applications are more or less in the same spot that other change of status applications are in. I mean, they still take forever, but you don't have to keep filing change of status to that of a visitor for a year and a half to keep your eligibility for your F1 status, your F1 change of status application. Yeah, a little bit in the weeds, not perhaps super interesting, but it's going to be very impactful on a lot of people, save a lot of people a lot of time, and my hope is also save a lot of processing time, because now we don't have USCIS adjudicators who have these stacks and stacks of B2 applications that they have to get through just because somebody's required to file it before their change of status to a student can be approved. I guess that's long and short of it. I'm sure there's tons of questions and everybody wants a lot of clarification on that topic. Happy to go into more detail on it, so please feel free. But yeah, let's go to questions, I suppose. We were just saying before we got on the call, the live, whatever you call this, that there isn't a whole lot of updates underneath the lawsuits. I think the most I've heard is that in Penn, there's been a lot of folks who have had their cases transferred, but pretty much everywhere else we were where we were last week. Motions to dismiss have been filed, and waiting on judges' decisions. I guess one update on Kinsley is that we've filed the joint appendix, which is basically just saying, hey, judge, here's the documents that you need to look at. But not super substantive. It's really just kind of like a table of contents of here are things that are relevant to the lawsuit, because the actual administrative record is 800 pages long and we don't want you to have to read the whole thing. Yeah, I guess with that, let me go to the top and start clicking on some questions. Anything new on Manila K1? Fortunately not. Still waiting on the decision on the motion to dismiss. Everything's been briefed. We're kind of just waiting now, unfortunately. One specific to Aaron.
Hello, Ronald. So the question is, oh, wow, I like his avatar. What does it say? Let's get vaccinated. That's cool. The question is, how do we think the government will implement adjudications of processing where there are different lawsuits going at the same time? Will they pick specific numbers of plaintiffs from each lawsuit? So I think he's asking in regard to the DV 2021 litigation, where there are numerous lawsuits. I think he's asking, will there be, a situation where the judge says, hey, pick 100 plaintiffs from Go and 100 from Good Luck and 100 from another case and adjudicate those and then keep going like that or something like that? No, I don't anticipate that would be the way that the judge would rule. I don't anticipate that would be the way that the government would process the cases. No. As far as how will they process them, I don't know. It depends in part on the wording of the judge's order. And so I think what we are confident in is that the government doesn't have enough time to process as many applications as are pending before September 30th. And because of that, from the beginning, we've been asking for them to reserve visas for beyond the September 30th deadline. Exactly how they'll go about ordering those, we don't know.
All right, moving on to another Go question. This is going to be Aaron all day today.
Let's see, this is from Aircon. I'm sorry if I mispronounced that. Government lawyers implied that to Good Luck lawyers that they will not give priority to any plaintiff in the class definition, since there are more selectees and only 55,000 available. If our visas are not processed by then, are the visas reserved to Go plaintiffs? Not necessarily. I can't say that definitely the judge's order would say that all Go plaintiffs are going to have their visa slots reserved for them. I just can't say that. What we have asked for is as many as possible to be reserved, but we've also asked that for our plaintiffs that they be adjudicated. And so we have asked that our plaintiffs in effect be prioritized, because we're asking directly for the adjudication of their visas. How the judge rules, we don't know. We don't know exactly how that'll play out. As far as the point that the government lawyers had implied that they won't give priority to any plaintiff in the class definition, that's typical. A class definition is usually more general than that, and a lot of times named plaintiffs in the class go first among equals. So it's possible that that people in the litigation could have some benefit, even if it's a class certified decision.
And I apologize. I don't know how to put Aaron's face up higher, so he's hidden by comments. And
no, that's good.
That's going to just continue.
That's a good thing.
All right. So, is it possible the State Department response to a K1 individual mandamus lawsuit is to dismiss it because the petition approval expiration date has passed? So, I suppose initially, I would say it's not the State Department's decision as to whether to dismiss a lawsuit or not. They'll argue that a case should be dismissed for a variety of reasons. I mean, the one that we see most often is we are the State Department and you cannot sue us. Just kind of like unilaterally saying, judges, you are not allowed to look at what the State Department does, which is kind of a nonsense response. But they can argue that, hey, the I-129F's approval date is only 4 months, and we're past the 4 months, and so this case shouldn't even move forward, because if you order them to adjudicate this case, judge, they're just going to, the consular officer is just going to have to kick it out anyways, and as you said, send it back to USCIS. I think that's a losing argument. I mean, consular officers have the ability to revalidate petitions beyond the 4 months, and they've already said that they're going to do that in these situations, because COVID has made it impossible for a large majority of folks to get their appointments before that 4 month period is passed. So I think the short answer is they could try, but I don't think that the judge would buy it.
Yeah, I would agree with that, and I just can't imagine how a judge would react if they had published, which they have, that they're going to be revalidating these as a matter of course for all these cases, but then in a specific case where there are plaintiffs that they're trying to get dismissed, they say they're not going to do it. I mean, that would look very terrible for them to try that. So I don't even think they would try it, to be honest.
All right. Any news regarding Cairo spouses? Actually, I'm not sure if this news was from last week or this week, but I guess the big update there is the judge said, okay, we'll grant the stay. So not a huge update, just that, as we talked about before, we were agreeing to the stay, and the judge said, okay, cool, we'll hold off on this until later. All right, another one for Aaron.
This one is, sorry, my printer just started going randomly. Give me 1 second, I'm sorry if that's loud. Says Ronald is documentarily qualified. Is he in a good position to get adjudicated before October? And also, should there be a worry about other plaintiffs from other cases? I mean, are you in a good position to get adjudicated before October? It's late July. I mean, nobody's in that great a position to get adjudicated before October, absent an order from the judge, even if you're documentarily qualified. If you don't have an interview notice yet, we're starting to get down to the wire. So, I mean, it could happen, and we hope it would happen, and we hope that a judge orders adjudications before then. But we can't know. Should you worry about good luck plaintiffs? No. I mean, we already knew before anybody signed up for this litigation that there were far more selected people for the diversity visa lottery than there are slots. And the plaintiffs from other cases, including good luck, they're just other people who were selected who are also vying for visas. So I don't think there's any reason that you should worry that the judge would make an order that grants other litigation priority over us. I just don't think that'll happen. It's impossible to envision it happening. The Go case is the most far along in the sense that it is a motion for summary judgment that is pending a final decision. So in that sense, the Go plaintiffs are the best off.
Another one for Aaron.
That is Brandon Go. Hi, Brandon. So,
all right. Gut feeling about when the Kinsley case will have a decision. soon, quickly, etc. Like, we keep saying that we think it'll be soon. As far as specific dates, it is so hard to say because, I mean, judges are kind of, kings in their own castle, and they can make the decision when they want, and there's nothing we can really hold them to. I think that if we're going based off of previous decisions from Judge Boasberg, let's see, so Milligan, we had the preliminary injunction filed, I think it was either late September or early October, and got the actual decision in mid-November, so about 6 weeks. So if we're going off of that exact same timeline, everything was kind of done Monday, and 6 weeks from Monday puts us late August, early September. But again, I mean, it's kind of impossible to say that's when he'll make the decision. And this is a big case. It's a huge legal issue that will, it'll have a lot of implications beyond just the plaintiffs in the lawsuit. So he could take more time than he did in Milligan to issue the preliminary injunction. Yeah, hard to say. All right, another one from Ronald.
This is about reservation of visas. Is there any way to make reservations more reliable for named plaintiffs? To that I would just say the lawyers on the Go team were hired to be your lawyers. So our loyalty is to you, the Go plaintiffs, and every step along the way, we will be asking for our plaintiffs to be issued visas or to have visas reserved for them. And to the extent that there's a court having status, requiring status reports or status hearings after September 30th, if there are reserved visas, we're always going to be pointing out to the court which of our named plaintiffs don't have their visas yet. And in that way, pressuring, hopefully, Department of State to make the adjudications happen. But that's all we can do for now is ask for the relief for our plaintiffs, which is what we have done and what we'll continue to do.
All right, another one for Aaron. This is Aaron's day today. They missed you last week.
Yeah. Khalif, I also like your avatar. That's cool. Basketball playing with the moon. I like that. So he says, sent documents 11/26/20, have followed up with lots of emails to KCC, and they just say they're still being processed. Is it normal? No, that's not normal. That's terrible. But it's also common. So it's not normal, but it is common that they're not processing people's documents at KCC. That's why anytime the court or a government lawyer says that they want to limit the relief or something like that to people who are already documentarily qualified, we're going to object and raise hell about it. Because the reason that people are not documentarily qualified is because KCC hasn't reviewed their documents. It's nothing that they've done. So no, it's not normal. Yes, it's happening a lot. And yes, we're addressing this as part of the litigation.
All right, so Milligan round 2. Manila is manipulating the receipt dates of when NBC sends the file. Not surprised. NBC told this person that they sent on March 1st, but Manila says the receipt date is September 15th. Lily was going to send the declaration template, but hasn't received it. I'll follow up with Lily about that. But honestly, I'm not surprised about Manila's malfeasance here. I would say, I mean, just based off of everything we know, they're just not doing their job with K1s. The numbers from August, I think, are the exact same that they were in May. So yeah, Manila's a problem. They're acting like a problem, and it's, I think, very clear that they are a problem. So I think this is just one more example of that. But yeah, I will follow up with Lily about sending you the declaration template. And then another for Aaron.
Thank you.
It's just going to be for the rest of the time, Aaron. You might as well just be host here. Oh, we still got that.
We did not.
Sorry.
This one, can you clarify for plaintiffs, how the case only asks for plaintiffs and at the same time not ask for priority for them? I'm not sure that I understand the question. We're asking for priority for our plaintiffs by asking for, with our request for relief, that our plaintiffs get their visa applications adjudicated, and saying that they're all subject to unreasonable delay based on the malfeasance of the Department of State in administering the diversity visa lottery program, and saying our plaintiffs should get their visas adjudicated. So that is asking for priority. I don't know what you're saying that we're not doing for as far as priority, but that's what we're doing.
Okay, another for Aaron.
Nabil, I did, and to anybody who has emailed me in the last 48 hours, I've probably received like 500 emails with lots of attachments on each of them. And so I've gotten back to most of you, but a lot of people I haven't quite gotten back to yet. That's okay. I will work on it. But first, we have a filing due tomorrow, and I need to shift my focus to that because otherwise I can't get anything done. So if you haven't heard back from me, that's why.
All right, Cecilia, we I think already touched on this already in an earlier answer.
Yep.
I'm just going to move on. It's about the class.
The question, I think, is, will Go plaintiffs be in the class? So the class is, there was a motion, let me back it up a second. There was a motion for class certification in a case called Jacob, now called Rosales, in the Northern District of California. That whole case was moved to DC and to Judge Mehta. The only thing that was before the court on Monday in that case was basically some basic questions about scheduling, because Judge Mehta just got the case. But one of the things he said was, well, I see this motion for class certification. Can't you all just stipulate to a class? Talking to the attorneys for the Jacob/Rosales case and the attorneys for the government. We can't stipulate to a class because we don't have a class certification. We haven't sought it, and we don't, at this point, we don't see the advantage to it for our plaintiffs. Depending on how the language of the class is written, depending on how everything's written, could that change? I guess, but I don't see it right now. And that's something that we would have to be obviously in touch with our plaintiffs about. But as of now, we don't have control over that motion. It's not a motion that's pending before the court in our case. And we don't have plans to try to get our plaintiffs into that class or excluded from the class. We're just kind of observing, and we'll insert ourselves where necessary. Sorry if that's not much clarification, but there's not much clarification on our side either.
All right, question on, I guess, relief for Go if the case drags out a little bit longer.
If the diversity visa is not issued by September 30th and not reserved for plaintiffs, what is the meaning of winning the Go lawsuit? Do you understand that, either of you, Luke or Zach?
So, I mean, I think he's saying is, I mean, the diversity visas will expire on 9/30. So, I mean, statutorily, they won't be qualified for those visas anymore. So if we win and the judge says, okay, you have to issue visas, I guess what happens? I guess in the end is asking, what happens if we win after September 30th? And I think the answer is that we still win. I mean, the judge isn't going to order relief that's meaningless. The judge is going to either reserve visas or as he did previously, he said, as soon as the proclamation expired, those visas had to be immediately issued, things like that. So I think in the end, it's a question about what relief could the court order after September 30th. Hopefully that was good enough. You didn't get Aaron, I'm sorry. But here's another person for Aaron.
This is from Alexander Popoff. How hard is it to prove standing as requested by Judge Mehta, or is it more of a formality? it's not a formality. I mean, it's a requirement, and cases can be won and lost on standing. That said, to me, it's not a close call. I think we had actually proven standing with our initial filings, but he issued this order to all of the cases at the same time, saying he wanted more on standing. So, could it have been that other cases didn't address standing as much as I think we did? Maybe, or maybe he just felt like he needed to bulk it up for all of us. But I do feel like we're in great shape on standing. So we'll have that filing in tomorrow as requested by the court, and the government will have till the 30th to file its response.
All right. So in Morocco, higher number cases are getting appointments, where lower number cases are not. I think this is the kind of the crux of the argument that was being made, that there are lower number folks who are being adjudicated after a higher number of folks, and Judge Mehta wanted specific examples of that. And I think that Chuck was providing some even in oral argument. So the judge is aware it's suppose an issue that he is fully aware of and has specific examples of. Another one for Aaron. Sorry, I took that one from you.
No, that was helpful. Thank you. Nabil, what type of plaintiffs have we chosen? Well, we're still working on this filing. Like I said, I got many emails with many attachments. So I'm not 100% sure on which ones we're going to use yet. But I can tell you what I'm looking for. And first of all, a lot of people are emailing me these documents. They really want to be the ones chosen to be included in the standing. You don't get anything from it. You're not going to get relief where other people don't just because you were looked at for standing. The judge just wants one example, and it can be a few, but what he asked for is one example of a plaintiff who clearly meets the standing standards. So what we're looking for is, frankly, a case where the client is documentarily qualified, has been for a while, where there are case numbers that are higher than theirs that have already been adjudicated, showing at the same consulate, showing that the consulate is working. We want it at a consulate that is not shut down for whatever reason, whether it's COVID, whether it's diplomatic reasons. Why? Because for the standing part, again, this is a very narrow issue, but we don't want them to be able to say, well, even if we had been processing cases the whole time, we don't think that this person would have gotten a visa interview. And because of that, I don't want them to have an excuse that, the Moscow consulate's shut down anyway. So it's not this that's causing the injury, it's something else. So we're looking, so it's probably going to be somebody who's not from a consulate that's been shut down and where other types of immigrant visas have been processed throughout the year. So that's what we're looking to present, and I don't have a name or even a number of plaintiffs that will be included. But if you are included, thank you. If you're not, please don't worry. It's not because there's anything wrong with your case. It's because we're looking to address one narrow issue from the judge, and people who are included are not going to get anything special out of it.
All right, a couple of questions that we already answered about priority and the chances of cases being adjudicated before September 30th. I'm going to move on to one that I can answer. What is the joint appendix that Judge Mehta requested for Go? So I just did this for Kinsley, and that's why I'm going to take it. When we get the administrative record, which is basically everything that was before the agency when they made a determination, it can be long. In Go, it's like 800 pages. Same thing in Kinsley. It's long. The judge doesn't want to read 800 pages of useless and I guess not applicable material. So what the judge requests is you to work with the opposing counsel, put together basically a table of contents, identify the parts of the administrative record that are pertinent to the lawsuit and that are being relied upon by the parties, and submit that to the court. And so then the court, rather than having an 800-page document filled with things that don't matter, has a 100-page document filled with things that are extremely on point and everything that the parties are relying on. Really, it's just a way to speed things up and make things easier for the judge, and that's why they request that.
I can take this. Yes, I think we can expect that there would be no decision before the 30th of July, because not only is that when the joint appendix is coming in, but that's when the government's filing on standing is due. So the judge isn't going to issue a decision before that.
So, I mean, this is, I guess, going back to KCC issues. Get yourself documentarily qualified. But yeah, beyond that, it's hard to say who can get appointments before September 30th.
Yeah, I mean, if you've done all you can and you are continuing to follow up with KCC, that's all you can do, is document your efforts and make sure your documents are in. It's not your fault that you're not documentarily qualified. As long as you've sent everything that there is, it's their fault, and we're bringing that to the court's attention. Is it possible that they'll documentarily qualify you and get you an appointment before September 30th? Yeah, it's possible. They can move fast, especially if a judge orders them to move fast. But we don't know, and I think it's probably at this point unlikely without a court order.
Aaron, a lot more kudos to you. You know, feel free to give me kudos as well, guys. I don't mind at all. Anyways, let's see.
Oh yeah, no, I know this. They say don't send us. They say don't send us documents without our request, but then in court they come back and say, well, they haven't sent in their documents. They're talking out of both sides of their mouth, the government, and Chuck brought this up at the hearing, and it's been raised in pleadings as well. So we know.
So this goes a little bit to, I guess, the scope of representation. We don't represent you specifically on your diversity visa case, so we wouldn't enter our appearance through a G28. So that, I suppose, wouldn't be necessary unless we were hired to specifically work on your diversity visa case.
Let me add in something on this, because I get a lot of emails about this. Saying, hey, should we hire you or one of the other firms to represent us directly in our interactions with the consulate and file a G28. And again, to be clear, like Zach said, that's separate from the Go case. That's a totally separate matter. You'd have to contact our firm or Cuck Baxter or Siskin Susser and enter a representation agreement with one of the firms to represent you individually. Whether you should do that, I don't know. I mean, one thing I think sometimes people don't understand is having a G28 on file does not expedite your case in any way. We all represent people individually at the consulates and have our G28s on file, and we have lots of clients experiencing terrible delays. And it's not just because they have a lawyer in the case that people actually look at their documents or that the Department of State is more responsive. It just doesn't work like that. So should you do that? That's up to you. But what I don't want you to do is think that, one, it's required. It's not to get your case processed. Or two, that it's necessarily going to speed anything up. It's not necessarily going to speed anything up or give you a higher chance of getting your case adjudicated. The only, I think, advantage is you can have an attorney reviewing and making sure that all the documents and information submitted should be sufficient for what they need. But as you know, many people do this process without an attorney. Some do it with an attorney, but I don't want you to think that it's required or that we think every one of our plaintiffs needs to hire us individually as well. I don't think that.
All right. So I guess last question here we have. And it goes again to, can you get an appointment? We just don't know. I mean, we're getting towards the end of, a ton more questions came in. So not last question. Yeah, I guess we just don't know. As Aaron mentioned earlier, it's hard to predict. We're getting really down the wire here. But we're asking for relief that would let us reserve visas and let cases be processed past September 30th. All right, moving forward.
If we get a good order, if we get an order in our favor in the Go case, will all plaintiffs be prioritized regardless of our case numbers or being documentarily qualified? We can't know that. we're asking for our plaintiffs to be prioritized in the sense that we're asking for an order, ordering the Department of State to adjudicate their visa applications. How will the order actually read? We don't know. So there's just no way to answer that.
And I think that's probably a similar situation to here.
Yeah, I'll just add here is for people not documentarily qualified, we have made clear and will continue to make clear to the judge that documentarily qualified just means it's just part of the case of the delay. I mean, the fact that somebody's not documentarily qualified is just because KCC hasn't been doing its job in almost all these cases. So we're not going to leave anybody behind just because KCC hasn't done their job to get them documentarily qualified. That's part of our suit. The order should make KCC do its job and then get the cases to the embassies for adjudication. And if that can't happen before September 30th, then the visas need to be reserved to allow it to happen.
Okay, sorry, I'm not reading these in advance, so if these are duplicates, I apologize.
Yes, I know that plaintiffs who are chosen are not having interviews. What I want to show is choosing plaintiffs from 3 consulate types, 1 which did not process. Okay. I think this is referring to the standing filing, probably. Yeah, I'm not exactly sure, Nabil, but don't worry, we're on it. We're going to have plaintiffs that show standing, and that'll take care of everybody.
And when do we expect a decision?
Don't know, not before this July 30th.
All right. So I guess this goes to the process of appeal. Government appealed in Gomez as well.
But what happened? People entered in the meantime, right?
Mm-hmm.
Yeah. So I mean, the government, I think, generally can ask for a stay of the judgment pending appeal, but that's not automatic. So I think they would be processing the cases unless they got the effect of the order stayed pending the appeal. No, I do not expect that you would have to wait for an appeal before having visas issued after September 30th, if that's what judge made the orders.
And Alexander, I was totally joking.
It's Zach New and Luke Neerman.
Yeah, but Aaron,
is your name not on does it not show up on the screen?
It shows up if I take people.
Oh, yeah.
But I was totally joking. Aaron is like blowing this case just away. Like, he's done amazing work, so he really does deserve all the kudos. Yeah, totally joking. All right, and if we win appeal, can they go to the Supreme Court? That's I guess a maybe. When you appeal from a circuit court's decision, you have to file what's called a writ of certiorari. We love Latin in the law. And the Supreme Court can either take the case or not. And it's really kind of up to them. So it's a maybe. If we win on appeal and the Supreme Court doesn't take the case, then I guess we win, and that's that. But they could try to go to the Supreme Court, I suppose. Oh, we already answered that one.
Elizabeth thinks that Judge Mehta will just rule once and for all DV lawsuits at the same time. It could be, we have no way to know. He hasn't officially consolidated the cases necessarily, but it's certainly possible. So we'll just have to see how that plays out. Like I said, we asked for, and we have only one duty, and that's to our plaintiffs. And so we'll continue to fight for them to get relief. But that said, other selectees also have a legal claim here. And so the judge just isn't going to ignore people with a legitimate legal claim from one case and not ignore them for another case. So is it possible he'll address everyone in one decision? Sure, it is possible.
I guess this comes back to people who are not documentally qualified, but who have tried their best. I mean, this is, the judge knows, we know, it's not going to be, I think, dispositive on anybody's case, because this is clearly the government's fault that you're not documentally qualified if you've done everything right. So it's not something I would be overly concerned with. Okay. So this would be, I guess, similar to how DV 2020 was for Gomez. It gets reserved. They, I guess, hold off on adjudicating those cases until those visas are released after a final judgment, and then they'll start processing them once the judge says you have to. The government had some weird compromise of, we'll do it in 2023, but I won't speak out of turn. That seems silly to me, speaking out of turn. I mean, they're basically saying we'll cancel a different diversity visa lottery. That way we can deal with this one. But anyways, it's not my place to opine on that, I suppose. Aaron is best. We all can agree on that. Is the reserve visa, so at least in Gomez, when the visas were reserved, there was nothing saying that it was specifically plaintiffs, if I remember right. What the judge did say in his injunction is that named plaintiffs had to be adjudicated first and then everybody else. But as far as the reservation of those visas, I don't believe there were strings attached on that order saying that named plaintiffs had to be the first ones. We already answered that one. Check.
I don't know what that means.
I don't know if I have DMs on here. I'm sorry. I really do not know how this platform works. Try my best, but as you can see, that I don't even know how to do banners.
I think you did good.
All right. Well, anyways, that was the last one. Thanks everybody for tuning in. Hopefully we got some of your questions answered. Hopefully you learned a lot about F1s and B2 bridges. And yeah, I guess we'll see you guys next week, same time, same place. There is also the Monday update that happens on the Impact Litigation channel, where we'll talk a little bit more detail about all the cases as well. I won't be there. Aaron will, and everybody will talk about all the cases. Yeah, I guess we'll see you guys next week.
Thanks, Zach. Thanks, Luke. Thanks all.